Get ready. 3 seconds. 2 seconds. Start. A question of juvenility has been raised in respect of appellant numbers 2 and 3. Accordingly, by the order dated 13/2/2019 in LA number 677/2019 in connection with CRL number 187/2014, an inquiry was required to be made by the learned session judge on the question as to whether the appellant numbers 2 and 3 were juveniles at the time when the occurrence took place. Consequent to such order, a report dated 9/5/2019 has been submitted by the learned session judge with reference to Mice Inquiry Proceeding number 2/2019, by which both the appellants were held to be juveniles when the occurrence took place. According to the definition of child in conflict with law, the appellant number 2 and 3 having not completed the age of 18 years on 12/1/2006 when the occurrence took place, and they having been alleged to have committed the offense related to the occurrence, would be child in conflict with law. Section 1 of the JJ Act of 2015, inter alia, provides that notwithstanding anything contained in any other law for the time being in force, the provisions of the Act shall apply to all matters concerning children in need of care and protection and children in conflict with law, including death of apprehension, detention, prosecution, penalty or imprisonment, etc. On reading the proviso to Section 9(2) and Section 9(3), conjointly, it is discernible that if the claim of juvenility is made at the appellate stage, that is, after final disposal of the trial, and any sentence thereof had been passed, such sentence shall be deemed to have no effect, and the claim of the child in conflict with law shall have to be forwarded to the concerned JJ board for passing appropriate orders. Section 15 of the JJ Act of 2015 provides that in case of a heinous offense being alleged to have been committed by a child who had completed or was about the age of 16, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offense, his ability to understand the consequence of the offense and the circumstances in which the alleged offense was committed, and accordingly may pass an order in accordance with the provisions of subsection 3 of Section 18, with further provision that for such assessment the board may take assistance of an experienced psychologist or psychosocial worker or other such experts, full stop para. In view of the orders to be passed under section 18 within bracket 3 that may provide for a need of trial of the child in conflict, comma, we also have to clarify that the preliminary assessment that may be made under section 14 within bracket 3 and further under section 15 within bracket 1 is not a trial but is an assessment only for the purpose of assessing the capacity of such child to commit and understand the consequences of the alleged offense, full stop para. We also take note of the provisions of section 24 within bracket 2 of the JJ Act of 2015 provides that the board shall make an order directing the police or the children's court directing its own registry that the relevant records of such conviction shall be destroyed after the expiry of the period of appeal or as the case may be, but is again subjected to the exception that in case of heinous offense where the child is found to be in conflict with law under section 19 within bracket 1 within bracket Roman 1, the relevant records of conviction be retained by the children's court and the requirement of destruction shall be inapplicable. Stop.